Yes, Mr. Knox.
My lords, my lady, I appear in this matter with John Carl Townsend on behalf of the appellants, and my learned friend Mr. Robert Young Clement, KC, and Mr. Gabriel Buttermore appear for the respondents. My lord, just a couple of housekeeping points. I think you should have received essentially a note from us and also a corresponding note from my learned friend saying what has happened to the properties since the judge's order. I don't know if those have been...
I don't think we've received any such notes.
I don't think, my lord, it actually matters.
Fine.
But we thought you might be interested, my lord. If you're not particularly interested in that, well, my lord.
Well, at the moment, that doesn't seem to us to be of central importance now.
My learned friend also sent a reading list, which I should have sent, but I don't know if you have received that.
We did receive that, yes, thank you.
I should have sent that. And I do
thank you to Mr. Temmick.
My lords, my lady, you'll see this is an application for permission to appeal against the order of Nicholas Thompsell.
Yes, well, on that question, we have, of course, read the judgment, we've read the scholars and arguments, and our provisional view, subject obviously to what Mr. Temmick has to say, is that we're minded to grant permission. But in any event, we'll obviously hear a full argument.
My lord, I was anticipating that I would present, so to speak, a full as opposed to a sort of summary argument, so I will proceed on that basis.
Yes.
My lord, you'll have seen that by the judge's order, he ordered, amongst other things, that 4 properties, that is the Schedule A properties, which are in various parts of London, be transferred to the respondent at the hire of A, a valuation that had already been carried out by Alexander Lawson & Co. back in June 2022, and B, a valuation to be carried out pursuant to his order by an expert. That valuation has yet to be carried out, although we understand a draft has been sent to the parties. In essence, the judge held that this would be an appropriate way forward because the appellants owed the partnership a judgment debt of about 3.6 million, inclusive of a lot of interest. And so, therefore, he held the respondent was entitled to call for a transfer of these 4 properties in satisfaction of that debt. That was the essence of his reasoning. And that is why he said this was an appropriate case to depart from the normal rule that you have a sale by auction, or at least a sale by private treaty. We say that the judge was wrong to order a transfer, a forced transfer in effect, to the respondent of these 4 properties. We say that he should have ordered that none of the properties should be transferred to the respondent, and that all 4 properties should be sold at auction, or at the very least by private treaty, and that the judgment debt of £3.5 million odd was not a sufficient reason to depart from the usual rule that partnership assets should be realised by a sale rather than forced transfer at a value to be assessed. That's our primary position. Alternatively, we say that even on the respondent's own valuations back from June 2022, the value of the properties, the 4 properties in question, was about £5.575 million odd, and therefore even on his own reasoning, he should not have ordered that properties over the value of £3.5 million odd should be sold. He should not have ordered that properties over that value should be transferred to the respondent. He should have said, at worst, from our point of view, those properties which are tantamount to a figure of about 3.5 million, well, they should go in, to satisfy the debt, but not the properties which are above that. And I'll come to what he could actually have done, because the properties do quite neatly. There are various combinations which you can see could easily have been made to get the property valuations more or less equal to the judgment debt. Now, you'll have seen, my lord, my lady, that there was no stay on the judge's order, which was made on the 19th of December, and that after that order, these 4 properties were immediately transferred to the respondent on the 20th of December, and since then, the respondent has run these properties and incurred expenditure on them. And I should say that is one of the points I think my learned friend's updated note, which we haven't yet seen, tells you about, but it's also in evidence in any event, in part, as to that. Now, my lords, my lady, because there was no stay on the order, because the properties have been immediately transferred, when we sought this order, when we appealed, we sought an expedited appeal, because we need to get on with it quickly. And the respondent opposed that on the basis, initially at least, that the appeal was academic, because there was no power in the Court of Appeal to revest the Schedule A properties back in the partnership. On the 26th of January 2024, Mr. Lord Justice Lewison adjourned the application, our application for permission that is, into court with an appeal to follow. Permission was granted, and he ordered the respondent to file a respondent's notice on the point that there was no jurisdiction. In the event, the respondent did file a respondent's notice and a skeleton argument, skeleton argument is at supplementary bundle tab 9, page 145. In essence, what the respondent says is this. He concedes that the Court of Appeal does have power to revest the properties, but says that it would be inappropriate in the circumstances, given the trouble and expenditure incurred by the respondent on the Schedule A properties since the judge's December order. And see that argument in particular advanced at pages 145 to 150 of supplementary bundle 9.
Can I ask,
sorry, tab 9.
why is a revesting necessary? If you succeed in your appeal, the upshot will be the properties should be sold.
Yes.
Does it matter where the title is in order for that sale to take place? What matters is an order that they be sold.
Yes.
And someone be given carriage of a sale.
My lord, we fully accept that. The point was taken that there was no power to revest, so we say, well, there should be a revest. I think our initial order simply sought just that there be a sale by auction. Well, when the point was taken that there needs to be a revesting, I think we then said in a revised order that there should be a revesting. But my lord, your lordship is right.
One of the points that was taken initially, at any rate, was, well, there might be stamp duty or CGT or other sort of costs involved in actually physically transferring the title back. But it wasn't obvious to me why you needed to do that.
Well, my lord, we endorse that. We say it's not obvious, and in any event, even if that were the case,
you could do it.
You could do it. We just pay whatever our fair share of that is. In any event, my lord, one can see that costs don't appear to have been all that high, actually, but one can see that if the order is for there to be an auction, and in the meantime expenditure has been incurred solely by one partner of the property, then, my lord, there may be arguments as to whether we should pay for half of that or not.
Well, there'd obviously have to be various accounting, whatever.
Exactly, and that would fall within that.
Yeah, yes, nice.
My lord, my ladies, just to go back to the respondent's notice, there's a concession about the Court of Appeal's jurisdiction, so that's gone, and there's simply a question about what about accounting for all the expenditure. The second point taken in the respondent's notice was on the merits, and they say, the respondent says, the judge's order should be upheld for the further reasons. First, that the appellants had deliberately engineered a situation in which the estate, the executors of the father's estate, could not pay the judgment debt in question, so as to manipulate for them, I think it is said, a sort of advantage in these proceedings. And the second point they take is that the respondent had an emotional attachment to the properties, and the judge should have taken that into account. Subsequently, my lord, various bits of evidence have been served by the respondent on the trouble and expenditure. You'll see that at tab 14 of the supplementary bundle, page 172, as directed by Lord Justice Lewison, and we have made submissions on that evidence, which you will see at tab 15 of the supplementary bundle at 178 to 183. And on the 22nd of March 2024, Lord Justice Lewison gave the respondent permission to rely on that evidence. So it is before you. Now, what I propose to do is to proceed as follows. First, to summarise briefly the factual background, take you to just one or two points in the chronology, then to go to the main parts of the judgment, then to deal with the law generally, the cases generally, on when it is appropriate to depart from the normal rule that on a winding up, the partnership properties or assets should be sold rather than transferred by order to one or other partner. Then I will deal first with what I call our third ground of appeal. That is, that on any footing the judge should not have ordered the sales of 4 properties whose value had previously been assessed at 5.575 million, given that the debt in question was just 3.6 million. We say there was no basis for going above 3.6 million worth of properties, even on the judge's own logic. Then I shall deal with the first ground of appeal. That is to say, the judge in any event erred in law in holding that the unpaid judgment debt amounted to an exceptional circumstance, such as to justify an order that the properties be transferred to the respondent rather than sold at auction. We say he should have held that within the phrase as is normally understood, and indeed within as a matter of basic principle, no exceptional circumstances existed by virtue of the judgment debt of the sort required to justify the departure from normal rule. And we say there is hidden in this case a point of some importance, because it is very often the case that one partner will owe quite a lot of money to a partnership, whereas another might not. I might owe, for instance, £1 million to the partnership, and Mr. Temminck might owe £100,000. Is it really the case that Mr. Temminck can say, well, Mr. Knox is a net debt of the partnership, as between the two of us, £900,000, and therefore I don't agree that the partnership assets should be sold. And so I do submit that the notion that a judgment debt, an unpaid judgment debt to the partnership, or debt or judgment debt, it can amount to a special circumstance, such as to justify departure from the normal rule, is a matter of some importance generally, because one can see how that might expand, so to speak, into more and more exceptions to the general rule. And our position is simply this. Debts owed to the partnership are something that are taken into account in the working out of how the proceeds are to be distributed between the partners. They are not, at least in circumstances such as this, something to be taken into account in deciding whether or not there should be a sale. And my lord, the important point of fact, I'll come to it in more detail later, is this. There is no doubt that the partnership assets range somewhere between, it looks like, the total, about 11.5 million to 13.8 million, different figures. But on any footing, there was within the partnership more than enough slack to deal with the 3.6 million debt by way of accounting after sale. My lord, that's our first ground, and then I shall go to our second ground, which is essentially this, namely, even if the judge did have, or could properly have ordered a sale of properties, at least in principle, we say he erred in law or took into account irrelevant factors in making the order that he did. My lords, my lady, I propose, I do not propose to deal with the respondent's arguments in my opening. I propose to deal with them in reply to my learned friend. That's on the notice, on the respondent's notice point. My lord, first of all, can I just ask you to see the order that we seek? Perhaps I should take you first of all to the order that was made. That is at Core Bundle tab 6. And you'll see on page 53, after the preamble, page 54, you'll see the preamble at the top. Part of the preamble refers to specifically the various debts which haven't been restored and so forth. The relevant part of the order, paras 1 and 2 deal with the appointment of a receiver. That's no longer an issue. But paragraphs 3 to 8, am I right in saying, deal with the mechanism for evaluation rather than sale. And I don't know, my lords, my lady, if you've had a chance to read that yet, but you'll see essentially paragraph 3 is the operative paragraph, paragraph 4, 5 and 6 then set out the substance of the order, and then paragraph 7 and 8 set out the precise mechanism by which the valuer is to come up with his valuation. But it's really 3 to 6 you need to bear in mind for the moment. The rest is more mechanics. And one point I want to take you to in para 8, which is begins at page 55, but continues on to 56, is F. 56F. The valuer shall act as expert and not as arbitrator, and his final report as to valuation shall be final, except in the event of manifest error. And that, my lords, my lady, you'll have seen, is one of the points we express concern about. I think it's under the third ground of appeal, because that really does mean there could be a serious error, but maybe not a manifest error, but there's nothing we can do about it. We refer to, I think it's a Supreme Court decision, which discusses what is meant, at least in this type of context, by manifest error. But we draw attention to that in advance. As for the order we seek, you can see that we were ordered by Lord Justice Lewison to make clear what order we sought, but you can see that in the supplementary bundle, tab 11, at 165. And this is a skeleton we put in pursuant to Lord Justice Lewison's order, I think, of the 26th of January. This is the order we seek. Now, it's fair to say we do seek, pursuant to the suggestion that the properties had to be revested, an order that the 4 Schedule A properties be revested. And that was the addition to our previous order, which didn't have that. But it was suggested by, that was in response to the respondent's suggestion that we had to seek some such order. So we sought it. But essentially, it's paragraphs 3 to 8 which we're seeking to set aside. And the substance of the matter, no matter what the wording is, the substance of the matter is we say these 4 properties should go to auction. Or, my lord, if so be it, a private treaty. We would not object to that either. My lord, very briefly, if I can just summarise the background by reference to the chronology, which is in tab 5 of the core bundle, which has references, I think, to most of the core bundle, and maybe some of the supplementary bundle. And one can pick it up on the page 45. Now, my lords, my lady, there were 2 partnerships, but that doesn't matter for present purposes. But you can see on the 27th, about a third of the way down, page 45, on the 27th of October 2016, you can see this is Mr. Sidhu Senior, that is to say, the father of Andy Sidhu and the husband of Mrs. Sidhu. He's one of the partners, one of the 2 partners, along with Mr. Bahia, and he serves a notice of dissolution of the partnership, that's the main partnership under section 32 of the 1890 Act, 27th of October, and dissolving the partnership, I should add, on the 28th of October. And the reference for that is core bundle, page 200, paragraph 12. It appears in one of the skeletons. I don't think it's contentious. And then you'll see on some point, it doesn't matter when, but some point before the 19th of November, Mr. Bahia began proceedings. And then on the 19th of November 2018, this is Mr. Sidhu, I think the son, the executors of Mr. Sidhu. No, it can't be, sorry. It's Mr. Sidhu Senior and Mrs. Sidhu served the notice of dissolution of the Greatway Partnership under the 1890 Act, and the dissolution was as from the 23rd of November 2018. And then you'll see in the interval, Mr. Sidhu died on the 20th. On the 8th of November, Chief Master Marsh ordered both partnerships to be wound up and to take of a dissolution account with such inquiries as may be necessary. One then goes over to the next page, page 46. A long trial takes place before Joanna Smith, J, dealing with inquiries into the workings of the partnership, and she makes a number of findings which are set out. I'm not going to read them all out, under the heading of 12th of April 2022, page 46, going over to page 47. She gives answers to a number of inquiries, to the effect that my client, I think, owes, and the net effect is that my client owes about I think it's only about £1.2 million, but when you add up the interest, it gets to considerably more. And you see that on the 26th of April 2022 at a consequential hearing pursuant to judgment. The judge, Mrs. Justice Joanna Smith, orders my clients to restore, and advised to restore relevant sums to each other, together with interest after allowing for set-offs, and that comes to about £2.7 million to partnership and £480,000 to ASL. Now, ASL is, I think, Star Liquors. That was a company which was jointly owned by the two partners and treated essentially as a partnership asset. And it appears to be treated, so to speak, as a partnership, as if it were the same thing as a partnership asset in these proceedings. And then various orders are made for possession on the 26th of April, but they are no longer in issue. Now then, on the 17th of June, Alexander Lawson makes a valuation of 8 King Street, that's one of the properties, and then further valuations are made on the 8th or 9th of August 2022. My law's lady, I do apologise, I said these valuations were made in June, actually they appear to be made in August for the most part, but I don't think anything turns on that. And there are the valuations of all the respective properties. On the 20th, going down to the foot of the page, those are both Schedule A and Schedule B. And I think the Schedule A properties, just for your note, are number 2, number 3, that's Child Green. High Road is also a Schedule A property. Number 7, Broadway is also Schedule A, and 44 to 48 King Street, that's also Schedule A. On the 25th of October, Mrs. Justice Joanna Smith made an order, you can see what it is there, to determine whether the properties of the partnership be sold or whether they should be disposed of in a different manner. And that's the origin of these proceedings. And then on the 23rd of May 2023, going over the page, the respondent made an application for transfer of the 4 Schedule A properties. And at that point, the application was for the properties to be transferred to him at the valuations that had been given by Alexander Lawson. So that's the nature of the application at that point. We put in a statement in response disputing the Alexander Lawson valuations, and then skeletons, sequential skeletons you'll see over the page 51, where the parties set out their respective positions, dated here on the 2nd of November, and draft judgment sent to the parties on the 9th. And the judge hands down the judgment on the 30th. There are various competing orders, but the order eventually is sealed on the 19th of December. Now, can I just take you to what the party's original position was, just briefly, as set out in their skeleton arguments, just a couple of paragraphs, so you can see what the state of play was immediately before the hearing and how it changed at the hearing. If you go to the respondent's skeleton, 27th of October, at Core Bundle tab 12, page 181, you can see their position set out essentially at paragraphs 25 to 29. And essentially they say it's quite wrong that we should be forced to bid at an auction when there's 3.6 million worth of indebtedness which hasn't been repaid to the partnership, because they were saying the appellants could use, so to speak, that 3.6 million to outbid. That was the idea. So they were opposing it for that reason. We're vulnerable because of this unrepaid debt. And then secondly, they were taking the point that there was no serious dispute about the June/August valuations. You get that from paragraphs 25 to 29. Hence, when they walked into the proceedings, they were saying, we want a forced transfer at these values, and it's quite unfair to require us to be subjected to a bid, because we can be outbid because of the failure of the Sidhus to pay the judgment. And that's 25 to 29. That's the essence of it.
It's put on the basis that this is a way of enforcing the judgment debt, is that right?
Yes, and because they say it's impossible to enforce the judgment debt by suing the executors, because the executors have already distributed the properties which were in the estate.
Wouldn't stop the executors from being personally liable.
No, but they said that's just far too long way. That's a long way round. Why should we put all that expense? That was the essence of their case, and it's one of the points taken in the respondent's notice. I think, where I understand it.
The obvious asset against which to enforce is the estate's interest in the partnership properties, because the estate has a 50% interest in the partnership properties, subject to its liabilities.
Exactly. So in other words, you don't need to do it now. You can do it on the eventual distribution.
In which case you don't need to sue the executors.
Yes. But there you see that it's paragraphs 25 to 29. And then, can I just ask you also to look at paragraph 69 on page 191. Paragraph 69, as regards the partnership assets, which includes ASL and the properties it owns, the likely balance for final distribution is about 13.8 million. And the proposed interim distributions will nonetheless leave in excess of 2.7 million within the partnership. And there are various other cash assets. So I emphasise that because this is not a case where the partnership assets are not going to be sufficient, so to speak, to satisfy the indebtedness, or be used to satisfy the indebtedness on the final taking of accounts. Now, our skeleton argument, which is responsive, it would seem, the relevant paragraphs for today's purposes are at page 210, behind tab 13. And that is paragraphs 50.13 and 50.14, when in essence we say there's a mechanism for dealing with the supposed advantage we have of not having repaid the 3.5 million debt. And you can see how it's put by my predecessor in paragraphs 50.13 and 50.14. If I can ask you just to read those two paragraphs to yourself. And you'll see, in essence, what is being said there is you can resolve any possible unfairness by the fact of the non-repayment of debt by giving the Bahias a credit of £3.5 million odd in an auction, so that they do not have to make a payment to the partnership up to this sum on any Schedule A property. So for the sake of example, supposing one Schedule A property was bought for £3.5 million by the Bahias, they would not have to put their hands into their pocket. They would just say, right, that's the credit we have against the partnership. And at that point, as I understand the idea, both the Bahias and the respondents would be neutral as far as the debt is concerned. So the Bahias would have got the 3.5 million property, and we would then be forgiven our debt. And that was the proposal that was put forward, and the judge, as I come to later, accepted that was a workable proposal.
So you, just be sure I understood, the Bahias bid for a property at 3.5 million.
They offered the partnership 3.5 million for the property, yes, let's say, and they win.
And there's no higher bid at auction.
Yeah.
Then the partnership is treated, they don't pay any cash, but the partnership is treated as making a distribution to them,
yes,
of the 3.5 million purchase price,
yes,
and is treated as making an equal distribution of 3.5 million to you, which is set off against your debt.
Yes.
Yes, I see.
Thank you for that, my lord. Yes,
There may be, and I think this is one of the points, there may be tax consequences depending on quite how it's structured.
my lord, I think it was accepted that those tax consequences could be dealt with in any event. I do seem to remember there was some discussion about that, but if there were tax consequences, no doubt that could be dealt with. I think the judge may avert this. That could no doubt be dealt with by further arrangements. But the basic proposition, which the judge holds is a workable and fair proposition, was this. And there is no finding that because of the tax or possible tax consequences, it was an unfair or unworkable proposal. My Lord, I think that I checked with Mr. my learned junior, but I have a feeling there was some discussion about that in the transcript, which might even be in the transcript in this bundle. The other point taken in the appellant skeletons at paragraph 51 onwards, which was essentially there were a lot of problems with the Alexander Wilson valuation, and so it'd be quite unfair to order a transfer at the existing Alexander Wilson valuation. And I don't propose to deal with all the points that were taken there, because the judge more or less accepted in his judgment that there were quite a few problems with the existing Alexander Wilson valuation. Now, my lords, my lady, at the hearing in November, the respondent put forward an alternative proposal to the one which was in his skeleton. And that alternative proposal was that the properties, the 4 Schedule A properties, be transferred not just at the value assessed in the 2022 valuations, but at a value to be assessed by a single valuer. And you can see that if you go to tab 15, page 220. At the foot of the page, Mr. Temminck, you'll see there's some discussion earlier on about how this is all to work, but at the foot of the page, Mr. Temminck put forward a proposal as to there be a single value. And the respondents maintained their proposal. There was some discussion about it. I don't propose myself to go into the detail of it, but there was discussion about the respondents' the appellant's proposal at page 2, I think it's 222 of the same bundle, about halfway down the page, or a third of the way down the page. Mr. Levy, the way it will work is it's not fair. We, the Sidhu, have got 3.5 billion. That should be not be in our pockets. It should be in the partnership, yes. Mr. Levy, and what we are saying is you have a credit of 3.5 million, so you do not need to come up with the cash. You have a credit. And then there's a bit of discussion, quite a bit of discussion about that between the judge and Mr. Levy on the following pages. And it may be at some point the tax point is raised, but anyway, it doesn't seem to be featured in the judge's judgment. My lords, my lady, for your note, that's where the proposal is dealt with in oral argument at the hearing. I should have added, it will be obvious in any event, there was no evidence called at the hearing. It was simply on documents. One then goes to the judgment, at tab 7 of the core bundle, page 60. The discussion of the legal principles begins at page 63, paragraph 16 onwards. I don't propose to go to the judge's discussion of the legal principles because we say it's not so much what he says about the principles, but the way he's applying it is wrong. So that's paragraphs 16 to 25. And then page 66, paragraph 26, 27, he summarises what the parties' eventual positions were, and that's 27 and 28 for the respondent. If I could just ask you to read those paragraphs. yourselves, where he summarises how the respondent's position is moved. That is to say, you can move away from the original valuations and you go to the valuation or the existing valuation, or if higher, the new valuation. You don't need to trouble about 28A, it's really 28B, which is what matters. And while I'm on this page, you will here see the 4 Schedule A properties and their respective values. And you will see that, in fact, curiously, that if you add up 1 and 2, you get about 3.6 million. And if you add up 2, 3 and 4, you get about 3.6 million. So that, in a sense, is what fuels, in particular, our argument about why do you order 4 to be sold rather than 3 or 2. But anyway, whatever combination it is, you can get to 3.6 million quite easily, if that's the right approach at all. And the judge accepts paragraph 30 that the second of these points, namely the valuation point, let's have an independent valuer. He says, does constitute a very substantial concession and provides an answer to some of the main complaints that the Sidhus have made concerning the claimant's original proposal, based on their concerns regarding the brackets existing Alexander Lawson valuation report. You then go to paragraph you go to paragraph 32 for a summary of the appellant's position. And he explains the concession that a credit be given to the extent of the debt, and why we have given it.
It says it can be documented in a similar way, so that the tax treatment,
Yes,
according to you, would be the same. I don't know whether that's agreed or not.
don't think there's any respondent's notice saying the judge got that wrong. My lord, yes, but my lord, that is the finding of the judge. And even if it wasn't similar, my lord, it's not being suggested that that would make a material difference. So those are the 2 competing proposals which he then goes on to consider. From paragraphs 36 to 58, he goes through the pros and cons of these 2 proposals. I don't propose to take you through all of that. You'll no doubt have read it in any event. But I do just want to draw your attention, in particular, to paragraph 39 on page 68. He deals with the point about there being an unlawful extraction of value from partnership in paragraph 37, that being the respondent's, I think it's fair to say, main point. Paragraph 38, he says, well, that's already been dealt with by the judgment and the interest and so on. But paragraph 39, he concludes, however, I do consider that there remains something in the claimant's point, in that, as the injured party, he should not be kept out of receiving value from the partnership, including the monies which the court has ordered that the Sidhu should repay, restore to the partnership, any longer than is necessary. Mr. Levy has challenged the principle of this argument. He has pointed out that if the claimant wishes to obtain payment of the judgment debt, he can pursue other means of collecting this. Nevertheless, I accept the claimant's case that the major difficulties in bringing enforcement proceedings where, against the estate of the deceased, where substantial assets of the estate have already been paid away. In my view, there is a major advantage in the claimant's proposal in that it would allow the claimant to extract value from the partnership almost immediately and, in effect, to receive payments in respect of the judgment of debts. So that, in essence, is the main point which the judge appears to rely on. The other passage I would like to draw to your attention is paragraphs 49 to 50, I don't, this is merely for your note, I draw attention to 49 and 50 on page 70. It's really just the last sentence, of paragraph 49 and paragraph 50, which I would like to emphasise. If I can just read those to you. Whilst these references have been explained as arising from the use of a template document, Alexander Lawson has confirmed that it did not produce its report for the purpose of open market value. I agree with Mr. Levy that the lack of care on this point would be of concern to someone invited to rely on the report. I would have given these points considerable weight in relation to the original iteration of the claimant's proposal, where these properties were to be transferred at the values contained in the valuation report. However, in the revised version of the claimant's proposal that was discussed in the hearing, I consider these objections are fully negated by the proposal that appear further independent valuation. And if that shows the portfolio acquired by Mr. Bahia to have a greater value, for that greater value ascribed to the property. I just emphasise that because there's no doubt the original Alexander Lawson report was found by the judge not to be reliable. We couldn't place proper reliance on it. Also, at page...
Can I just ask, if the independent valuation, which you say is in train, produces some values that are higher and some values that are lower, do you get globally the higher of the cumulative value, or do you get for each property by property the higher of the two values?
My lord, my understanding actually is the latter, under the terms of the order.
That's your...
I don't know whether Mr. Claimant agrees or not.
Well, my lord, we have the advantage of the draft independent single joint report in court today, and the valuation from that single joint expert is 5.4 million,
right?
Rather less than the Alexander Lawson values. All of the values are different, two are higher, two are lower, but the single joint expert values those four properties at almost £300,000 less than Alexander Lawson.
As you say, that's globally, and some are higher and some are lower.
Yes, and as to the mechanism, the way the Bahias understand the judge's order is that they would be liable to pay the increased amount, but they don't get the benefit of the reduction.
So it's done property by property basis.
Yes.
Yes. Thank you.
I will hand up the draft summary that my learned friend had said before the hearing he intended to rely upon, so your lordship have it.
Thank you.
I'm obliged. My learned friend, just before I revert, has drawn my attention to the other passages where the tax point is dealt with. That's at paragraphs 46 and 47 at page 69. Page 69.
Sorry, can you give that again, please?
Yes, 46 and 47.
Thank you.
Page 69. I think actually here, this is where he is dealing with his reasons for wanting to buy the property. I'm not sure if in fact it takes things much further than the paragraph I showed you earlier, page 67, paragraph 32. The next passage I want to go to is on page 72, paragraph 55. I should draw your attention to this. It's 55 to 57, but then you get the gist of it from 57. And what the judge said is this: had I formed the impression there was any real desirability on the part of the Sidhus to acquire any of the properties, I might have considered introducing into the arrangement some device to allocate the properties fairly between the sides, but I didn't consider this was the case, and in the absence of there being a genuine desire and ability on the part of the Sidhus to purchase particular properties, I attach very little weight to that argument. My lords, my lady, we say, well, that's just not a relevant consideration. It's the market that matters more than anything else. And then, my lords, my lady, page 72, paragraph 59, a passage on which we do particularly rely on all grounds. 59, conclusion. Having considered carefully all the arguments put before me, I am persuaded that I should favour the claimant's proposal, as has been developed above. Whilst both proposals are workable, and it would not be unfair as such to order either proposal, I consider that the claimant's proposal has a number of advantages, and that the circumstances render it just that I should choose this proposal. And he then goes on to summarise his 4 main points, I think, in conclusion. The first is swift repayment of judgment debts. That's paragraph 60. Second, it avoids additional costs of an auction, but he says that's tempered by the additional cost of an expert report. My lord, my lady, just pausing on that, there was no evidence at all as to what the additional costs all in of an expert report would be, because that idea had only been used or come up with at the hearing itself. And it is a point we criticise, because of course auctions always cost something, but I submit it's naive to suppose that single joint valuers don't end up resulting in quite a bit of cost, A, for the valuer, but not least for the parties' lawyers, putting forward arguments about what the right value should be, especially when it's a single joint valuer whose decision is binding, say, in the case of manifest error. He then, the next point is 63, he has regard to the fact that Mr. Bahia, as the only former partner, is entitled to a say in the means of the disposal of properties, while such entitlement doesn't entitle him to propose something that would be unfair to the estate of the other partner. Where there are 2 proposals that are both fair and workable, I think it appropriate to have regard to his wishes in exercising my discretion. And my lords, my lady, we say that's just not relevant. Here we're talking about the winding up of assets so that the estate gets what is justly due to the estate. It makes no difference that Mr. Sidhu, the partner in question, has died in the meantime. And then, that's paragraph 64, to place my decision in the context of the remarks of Lord Justice Hoffman and Hammond and Brearley, I acknowledge that departure from the normal order of sale by auction is exceptional, but I have the discretion to make such an exceptional order, and for the reasons I've outlined above, I consider that the order I propose suits the justice of the case. And I will, and so forth. Now, my lords, but hey, what we said about that is, well, here you've got 2 orders, both of which are workable. On what basis can it be said that there is an exceptional circumstance, that one order is a bit more workable than the other? And that really, in my submission, is our first ground of appeal. This is not exceptional. What you really need, I anticipate, what you really need is my proposal being unworkable and Mr. Temming's proposal being workable. Well then, of course, one invokes the exceptional jurisdiction. But you don't invoke it when there are 2 workable proposals.
Well, not really workable, but workable and not unfair.
Yes, yes, and not unfair. So I jump ahead, but you, my lords, my lady, you have my point. Now I would like just to go to the law generally, if I may. I'm not intending at this point to make any submission on any particular ground, but no doubt I will, since we can anticipate. But the starting point is the Partnership Act. And that's at tab 16 of the authority bundle, at page 297. And there are just 2 sections I want to take you to. Begins at 297. The first section I want to take you to is section 39. On the page 308. On the dissolution of the partnership, every partner is entitled, as against the other partners in the firm, and all persons claiming through them in respect to their interests of partners, to have the property of the partnership applied in payment of the debts and liabilities of the firm, one thing, and to have the surplus assets after such payment applied in payment of what may be due to the partners respectively, after deducting what may be due from them as partners to the firm. And for that purpose, any partner or his representatives may on termination of the partnership apply to the court to wind up the business and affairs of the firm. Now, the reason I emphasise a bit before the semicolons is what this is envisaging is that debts get dealt with later, if I can put it that way. You first of all pay off the liabilities of the firm. You then have the surplus assets applied in payment of what may be due to the partners, respectively, after deducting what may be due from them as partners. That's the stage at which debts matter. doesn't, certainly, I accept there's no exclusion of the possibility of a forced transfer in certain circumstances. But this, I submit, underlines the importance of when you normally deal with debts after the assets have been disposed of. I then go right to the front of this bundle to the case of sires. And this was a case where I think it was a case of a partnership between two brothers in a music hall business, where one brother, there was very obscure documentation, one brother was held to have acquired a 1/8 interest in the partnership. And if I can just ask you to read the headnote yourselves, because it gives us a useful synopsis of what the case is about. In the courts below, there have been differing views about what the nature of the arrangements was. But in any event, the House of Lords says the partnership came to an end, I think, when a particular document was served. It doesn't matter for present purposes. But if one can go, please, to page 12 of the bundle, at the foot of the page, in the speech of Lord Cairns. Therefore, my Lords, the result, in my opinion, is that there was a partnership, but that the partnership was terminated at the time of putting in the answer. My Lords, it is very true, as we've said at the bar, that on dissolving a partnership of this kind, the ordinary course would be for the court to direct the sale of the assets, and, if necessary, a sale of the concern as a going concern, and to give liberty for proposals to be made by either party to purchase it before the judge and chambers. My Lords, those provisions are moulded in every case by the court to meet the circumstances of the particular case. And it appears to me that looking, like it, emphasise this, looking at the nature of this business and looking at the very small interest which was taken in it by the respondent, it will certainly not be desirable in this case to have a sale or to bring these premises, musical premises I think, to the handle for the purpose of ascertaining what sum ought to be given. It is a case, therefore, in which, if a decree for a dissolution had been made in the first instance, I apprehend that the court would have thought it right to authorise the owner of the 7/8 of the concern to lay proposals for a purchase before the judge and chambers. And I'm about to submit to your lordships a provision, which I think will arrive in substance at that. And what Lord Cairns then goes on to do, he, first of all, in the third paragraph, he sets out how there should be a taking of accounts generally. But then, about 8 lines up, then an inquiry, from 8 lines up from the end, then an inquiry what sum would represent the plaintiff's 1/8 share in the value of the said musical business, and to have an if sold as a going concern, after deducting all charges thereon and all liabilities of the business. Then, on payment by the defendant to the plaintiff within the time fixed by the judge and chambers, of the £250 and the sums coming to him, and so forth, the defendant to pay the cost of the hearing, no other cost, the cost of the accounts and the discretion of the judge. Then, if the payments which I have specified are not made by the defendant, that is to say the 7/8 owner, direct the sale of the hall and tavern as a going concern. So essentially, we work out what the value of this property is, and then the defendant, the 7/8 owner, buys him out. If he doesn't buy him out at that price, then it goes under the hammer. And then one goes to the speech of Lord Hatherley. At page 19. At the foot of the page, he describes the nature of the dispute and the findings which should be made, but it's at the foot of page 19. I think, my lords, that the valuation proposed is all that, under the circumstances of this case, the plaintiff is entitled to ask. I do not think he is entitled, under the engagement he has entered into, I emphasise, under the engagement he's entered into, I was always looking back so to speak, as to what the parties really could have sensibly expected. Under the engagement he's entered into to ask for a sale of the concern, regard being had to the amount of his interest in it, and to the nature and character of that concern, which, of course, the Court of Chancery is always bound to look to. And my Lord, I would emphasise these words in particular, and the injury that might result from having a sale of a business of such a description as this is. Under these circumstances, it is quite competent for the Court to direct such a course of proceeding as has been sketched out by my noble and learned friend in the decree which is proposed now to be made by your Lordships. And I concur in that decree. So you can see the order at page 21. I don't propose to take you to it unless you want to do so, but you can see it's all set out, page 21, page 23. Perhaps I should just draw attention to halfway down the page on 22, subparagraph 2, what is directed is that an inquiry be made what sum would, on the 21st of February 1873, have represented Daniel Sires' 1/8 share in the value of the music hall and tavern, if it had then been sold as a going concern after the development. That's the essential. So what I submit one gets from this, and I say this is really the point which we say is the principle. If there's injury to the partnership by ordering a sale, you don't do it, or if it's entirely unworkable. But that's the sort of circumstance one's not looking at, well, one party's proposed, but they're both workable, but one's a bit more fair than the other. The next case I want to go to is the Hugh Stevenson case, which we refer to in our authorities, which is at tab 2. My Lord, my name is a very brief head note, page 24. Essentially, there was a partnership between an English and a German company. They carried on partnership, but until the outbreak of the First World War, which operated as a dissolution of the partnership. But after the outbreak of war, the English company continued to carry on the business and to use the partnership plant for that purpose. And it was held that the German company was entitled to a share of the profits and not just interest. Share of the profits made after the dissolution of the business by the carrying on of the business by the English company. Now, in the course of this decision, their lordships make a number, I submit, of pertinent observations about the rule that there should be, on a dissolution, there is the sale of assets. If I could just take you first to page 25, what the question was, so you can see the context, halfway down the page. The question raised by this appeal was whether the German company were entitled at their option to a share of the profits of the business made since the dissolution, or to interest on the amount of their share of the partnership assets under section 42 of the Partnership Act, or whether they were entitled only to the value of their share in the partnership as of the date, in August 1914. Mr. Justice Atkin took the latter view and held that the German company was not entitled to any of the profits or interest in the capital since the outbreak of the war. The Court of Appeal overturned him by a majority, and the House of Lords upheld the majority view of the Court of Appeal. But in the course of doing so, they talk about the nature of a partner's interest and rights on winding up. And the first passage I'd like to go to is at page 30, at the last paragraph. I want to emphasise a point here which is worth bearing in mind. The final paragraph. But in any case, even if these American decisions, which were being relied on by the English company to exclude any rights of the Germans, even if they were right, the consequence contended for by the appellants would not, in my opinion, follow. The question here is not of contract, but of property. That's the point I emphasise. And what is it as between two partners in respect of the property of the firm? Continue. If the English partner uses the machinery which was in part the property of the enemy partner, why should not he in justice make some allowance in respect of this use? The price representing the value of the interest in machinery has not been paid. I don't think it would be importance for the laws for our declaration to stand, which would bar all right to share in the profits. And then, on the same page, page 31, Viscount Haldane, final paragraph, he too goes back to the underlying principle In the absence of a special agreement to the contrary, and there's none such in the contract for us, the rule is that on a dissolution of partnership, all the property of the partnership shall be converted into money by a sale, and that the proceeds of sale after discharge of all partnership debts and liabilities shall be divided among the parties according to their shares. If there is a special stipulation giving any partner the right to purchase another partner's share, it must of course receive effect. Here there is no such. And the reason I emphasise that is, of course the partners can make a special arrangement, but if they don't, then it is implicit in the whole nature of the partnership that there is a sale of the property, unless it is damaging to the partnership. That is the underlying point. And then he goes on to say, it shouldn't make any difference that one of the partners is a German alien. The next passage I would like to refer to is in Lord Atkinson's speech. And the first point is, he makes quite a long speech, but the first point is page 35. Where he explains at the foot of the page, about 7 lines up, he says, that's Lord Hadley, he says, it is trite law that a surviving partner cannot make use of the assets of a deceased partner without being accountable for the use he's made of them. The executors of the deceased partner have a right to a sale of every portion of the partnership property. So completely are they held in a fiduciary position, so complete are the assets, including the plant or houses, or whatever the description of property may be that comes into the hands of the surviving partner, by right of the survivorship at law, and which are all vested in the surviving partner by right of the survivorship at law, held to be property in all, whether chattels of the partnership or estates of the partnership, the executors of a deceased partner have an interest commensurate with the extent of the share of their testator. I emphasise this passage because one of the points, as I apprehend it, that's taken against me is, well, we're just executors. We therefore stand in a slightly different relation when it comes to deciding whether there should be a sale or not. And then on page...
Is that all about the situation where somebody dies in the course of the partnership, yes, so there hasn't been a prior dissolution? I thought there was a prior dissolution here.
There was, exactly. I mean, we say once there's a prior dissolution, that's it. I mean,
yeah.
But this seems to apply even before dissolution. We say there's no rules, so to speak. The executors get a raw deal when it comes to deciding on what's the proper method of winding the partnership up, or indeed what their rights are, qua executive. Page 36 again, about 10 lines up from the end. The same point is made by Lord Atkinson. And then at the top of page 37, in the present case, the articles do not empower the appellants to purchase the share of the defendants at a valuation, nor to take that share for themselves. In the absence of special provisions of that kind, no partner can, in ordinary times, with a view to dissolution or afterwards, force another partner against his will to submit anything of the kind. He goes on to give further references to that. And then at the foot of the page, he recites Sir William Grant, the Master of Rolls. The next consideration is whether the terms upon which the defendants propose to adjust the partnership concerned with those to which the plaintiff was bound to accede. The proposition was that a value should be set on the partnership stock, that they should take a proportion of it at that valuation, or that he should take away his share of the property from the premises. My opinion is clearly that these are not terms to which he was bound to accede. They had no more right to turn him out than he had to turn them out upon those terms. Their rights were precisely equal. To have the whole concern wound up by a sale and a division of the produce. As therefore they never proposed to him any terms which he was bound to accept, the consequence is that continuing to trade with his stock and at his risk, they came under a liability for whatever profits might be produced by the stock. It's slightly off the point, but this is on the page, and a small point about halfway down the page, he's talking now about the proposition that German, because one part was German. Lord Atkinson says of the proposal that of the respondent, it also deprives them during the same period of the right to sue in the King's Court to recover money due to them, but the continuance of this prohibition, and thus this deprivation for all time, though they should cease to be enemies, is a wholly different thing which not even the most rabid patriotism can justify. Well, it's not part of my argument, but I'll just put it in anyway. And then finally, in the speech of Lord Palmer, at the foot of the page, you get very much the same point.
Did you not want to take us to the passage on page 39?
39, my lady, yes, the case of, forgive me, you're quite right, sires and sires, it wasn't, yes. Well, at the top of the page, you have more of the point about partnership.
It's been sidelined. I
then
thought it was probably
yes.
sidelined by you.
Yes. No, forgive me. Well, at the top of the page, you have the
has a
same
right to
point.
insist that any particular part or item of the partnership property shall remain unsold.
Yes.
Well,
These are the general principles, and that's in Darby and Darby at the top of page 39. And then at the foot of page 39, he goes on to discuss, Lord Atkinson goes on to discuss the case of sons and sires. And I've taken that, so I don't need to take you any further what he says, except at the end of the paragraph, which is at page 40, the first paragraph. He says that the House had already held that a partnership in profits was a partnership in assets by which profits are made. The earlier part of the decree declared, as the order of Atkin J in this case purports to declare, the rights of the parties in the partnership assets. And I just emphasise this, the second part of the decree, in reference to which the above cited remarks were made, merely directed how the partnership should be wound up and the assets ascertained and distributed according to the right declared. The declaration of the rights of the parties is a strictly judicial proceeding to be made according to strict legal principles. The realisation of the assets and their distribution according to the rights so ascertained and declared is a proceeding of an administrative character, in which of two or more modes of procedure, all legitimate that one may be chosen, which is best suited to the special circumstances of the case. And essentially, therefore, what this is acknowledging, you start off by looking at the rights of the partners, but there has to be machinery for giving effect to those rights. And there may be special circumstances which make the machinery of a sale inappropriate. But we say that the sort of, I make my point. It's not this sort of case where if a sale is workable and not unfair, that's it. You go by the sale method. But what we're here talking about is machinery. What is the appropriate machinery for giving effect to the partner's rights? And what we say in summary is this. The machinery must be such as to give effect to the rights of equal distribution, if we're talking about 50-50 parts. Must be such as to give effect to the rights of equal distribution where this is fair and workable. Otherwise, there is a risk of inequality in the distribution, and a substantial risk, which is not something that, to use Lord Hatherley's phrase, it's not something, it was not really the engagement into which they entered, and you're departing from the underlying property, the point about the property being jointly owned. The next case is case of, I think it's at tab 4, is Privy Council decision in a case of action. And in essence, this was a case where one partner continued, I think having evicted the other partner, just continued to use the partnership assets after their, without consent. And then, once it had been proved that actually he had wrongfully removed his partner, he tried to say, well, what I want is a sale about 4 years down the line. And the courts in, I think it's Fiji, said, no, you're not going to have that. The matter went up to the Privy Council, who agreed. And you can see the reason begins at page 56, near the foot of the page. The relevant partnership back in Fiji was, in all material respects, the same as the one in the UK. And if I can just ask you to read from the two last paragraphs of 56 to the fifth paragraph of 57, for the reasons given by the courts below as to not ordering, for why they did not order a sale. the essence of it is, it's the second paragraph that I particularly like. This, that is to say, a sale, is not practicable in the instant case for several reasons. One of, not least of which, is being that the, as it were, the wrongdoing partners still claims to be entitled to all the assets, and he didn't wind up the business when it could have been. So how can you properly have a sale which gives effect to the partner's rights? The next passage is at the foot of the page, which deals with the Court of Appeal's judgment, which the Privy Council agreed. It's the last sentence, and really it is. I don't propose to read it all out or to ask you to read it. It's the last sentence. It's the last paragraph of 57, going over to the penultimate paragraph on 58, where I don't propose to read all of it out, but that sets out again in slightly more detail the facts which made it inappropriate for there to be a sale. But it's the passage in the third paragraph of 58 that is important, especially about 6 lines down. The power of the court is not confined to ordering a sale, but is a broader power, namely to wind up the affairs of the partnership in such a manner as to do justice between the parties. In the instant case, the sale of the partnership assets is not practicable. The appellant didn't carry on business after 30th September 78, as he should have done, with a view to winding up the business. He carried on the business with a view to continuing it as a going concern for his own exclusive benefit. The assets of Brunswick Motors, which are available for realisation in 1964, are not the assets which were available for sale and ought to be sold at the date of dissolution of the partnership in 1978. Instead, the Appellants Council came here to concede, if he did not actually concede, that a realisation of the assets of Brunswick Motors as that business now exists and the division of the proceeds between the partners would not be a fair mode of adjusting the rights of the partners to say. And then, my lord, the reason I emphasise this is at this point they then turn to, well, what else can we do? If, as is clearly the case, in order for a realisation of the present assets of Brunswick Motors partnership is not a proper method of ascertaining what is due to Mr. Martin, what alternative course should be adopted? The course taken by the trial judge affirmed by the Court of Appeal was to appropriate the assets of Brunswick Motors existing at the date of the dissolution of the partnership to the appellant at their balance sheet values and to make a valuation. There's a good example of when it's appropriate to depart from the normal rule. It's impractical. Can't be done. Next, one gets to the case of Hammond and Brearley, which is at page 60. And this was a decision of the Court of Appeal. And in essence, I think at first instance, Mr. Justice Harman, on an interlocutory order, had ordered a sale of certain assets belonging to, well, the claimant had a partnership share in assets, but not the goodwill of a business. And he comes along and says, well, I want a sale of the assets, even though there's not, I have no right to ask for a sale of the goodwill. And Mr. Justice Harman said, yes, you can have that, because that's the usual rule. And the matter then goes to the Court of Appeal, and you can see what the nature of the issue was by going to page 61. Penultimate paragraph on the 6th of December. If I can just ask you to read that paragraph, and then going over the page to the judge's reasoning on paragraph 62. That's, say, the first paragraph of 62, so you can see what the nature of the case was. And the important points in the numbered points in the first paragraph of point 4, the partnership was therefore dissolved by the issue of the writ. That's the finding of Justice Arnold, that wasn't contentious. 5, clause 17, meant that the plaintiff retained no interest in the goodwill which accrued to Mr. Brearley, say the defendant. Clause 17 required the remaining partnership assets to be dealt with in accordance with the Act. And then on the true construction of clause 17 and of the Act, the parties intended the assets should be sold, therefore it was right to make an interlocutory order for sale. And turning over the page, it's I think it's item number 7. Basically, the author agrees with the analysis, but it's item number 7, which is different, which they disagree. On page 63, and you can see how Lord Justice Hoffman puts it. And I just ask you to read paragraphs 7 and 8 yourselves. You can see, essentially, it's the same line of reasoning in paragraph 8. Before making a peremptory interlocutory order for sale, the judge should have considered whether the judge at trial might wish to exercise his discretion to wind up the partnership in some other way. In this case, it seems to me distinctly arguable that he might. The assets, other than the goodwill, which of course remains, in which the plaintiff by definition has no interest, the assets other than the goodwill have, as the judge pointed out, little value when detached from the business as a going concern. It follows that the plaintiff is unlikely to do better, and may well do worse, by sharing the prices realised by public auctions than by receiving his share of the valuation, in which the position of the defendants as special purposes can be taken into account. So that's one point. The plaintiff's not going to win, or unlikely to win. But the other point is this. On the other hand, an auction sale of the firm's computers, desks, and so forth may well be disruptive of the business and damaging to its reputation. In other words, without goodwill. And then he continues, the position would be quite different if the plaintiff had an interest in the goodwill, so that the whole business had to be sold as a going concern. In such a case, I think the court would be unlikely to demand the ordinary practice of ordering a sale by auction. But the present situation, in which the plaintiff has a share in minor assets used in the business, but no share in the business itself, is highly unusual and may well merit special treatment. The decision should be left for the judge. Mr. Justice Arnold is wrong to preempt it. Once again, there is a case where not only is it not likely to do the plaintiff any good, which is, as well, one thing, but also it's going to cause undue disruption to the business or the of the other party, because he's got his goodwill, but he's no longer going to have his assets, his computers and his equipment and all the rest of it. So it's going to be, it does him no good, it does no one any good. It's an entirely destructive order. So again, that's a good example of when you do bring science in. The next case is Mullins and Lofton, tab 6, and this I can deal with, I hope, fairly briefly. This is, I think, a firm of insolvency practitioners, and I think Mr. Justice Neuberger makes the point that it's a fairly rough and tumble world in that. But anyway, Mr. Mullins was treated very badly, and he was, I think, broad idea, he was called into the meeting and he was bounced, and eventually I think he decided he couldn't put up with it anymore. But the question arose, one of the questions that arose is, was Mr. Mines entitled to have a sale of the insolvency practice of that business? And one can take it, I think, first passage to go to is at page 101 of this, where Mr. Justice Newberg, as he then was, first of all deals with paragraph 107. You see, he says he takes a dim view of the majority partners. This was a minority partnership interest, I should say. They behave very badly. That's paragraph 107. And then he deals with the powers of the court, that it may wind the partnership up. And then paragraph 109, he turns to the Sire's case and Hammond and Brearley, paragraph 110. One then gets to paragraph 112, when he gives his reasons for not ordering a sale. If I can just ask you to read paragraph 112. Basically what's said in 112 is they could have got rid of him properly. And then paragraph 116, the conclusion, I can just ask you to read that yourselves. Essentially, they behaved disgracefully. They weren't allowed to do what they did do, but as they could have done what they did do, lawfully, by different means, it would be going too far to order a sale of the business, brought by the majority, an order to sell the business, which would obviously operate to the unfair detriment of the majority. But again, one can see there's clearly what you might call a special or unusual circumstance, which justifies departing from the usual rule. And then I think the next final case, I think, is Benji, which is at decision of Mr. Murray Rose, QC, tab 9. Now, at page 184, he turns to the family dispute. He turns to the sire's jurisdiction generally. And paragraph, you'll see what he says in paragraphs 46 to 48. He's talking here in general terms. And in particular, paragraph 48. And 49, I should perhaps draw your attention to. And what I emphasise in paragraph 48 is, if the court is satisfied that such an order, let's say some other order, would replicate financially what the other parties would receive on a dissolution, then the court can find what's a flexible and fair solution. You have to be able to replicate. And then there's a discussion, a general discussion of previous authorities, which I don't propose to take it to, but it carries on for 50. And 56 is his conclusion. He's talking about minority partners seeking being asked to sell their interest. It seems to me that in those circumstances, the court should be very careful before insisting that minority partners, in this case not a small minority, 2 out of 3, simply 46% of the parts, are not compelled against their will to sell to the majority, in this case the older brother, who had in the course of the partnership sort of exactly that, and when rebuttal had dissolved. Now, again, paragraph 79 to 80, conclusions. for paragraph 80. The evidence has demonstrated very clearly that a sire's purchase would create a grave risk of injustice between the parties, whereas a sale in the open market, but I want to emphasise these words, although it will no doubt be complicated, is entirely justified by the asset, by the values that are at stake, and by the potential for very significant joint reward, if the court enforces that sufficiently. And finally, of the relevant authorities, Malik, which I think is at tab 12. And this was, again, a family dispute. I think it's paragraph 32, if I can ask you to go to that. His Honour Judge Davis, I think it's His Honour Judge Stephen Davis, sets out, he begins the relevant passage at 28, paragraph 28 onwards, where he reverts to Sires and Hammond and Brearley, and then Lindley, but he goes on to deal with the facts of this case at page 256. And what he was concerned about in this case was that the partner who was seeking an auction was trying to engineer possibly a bidding war at auction, and so he's saying, well, that, you know, I can see that might be a reason for not going to auction and departing from the usual rule. And so you can see paragraph 33. However, if the only objective of the objecting partner is to attempt to, that's objecting to a transfer, is to attempt to increase the price by engaging in a bidding war with no genuine intention or ability to purchase, then I, for my part, see less force in the observation. In my judgment, this demonstrates that the search for further principles should give way to an emphasis on the particular facts of the case, given the wide width of discretion. I do not accept Mr. Mather's submission that there is a principle of general application that the court should decline to make an order against an unwilling partner for his share to be bought out, unless the court can be satisfied that there is no real risk of his being denied the highest price for his share from making such an order. I am prepared to accept this would be an important consideration in every case, and that in many, perhaps most, if the court was unable to be so satisfied, that would be a decisive factor against making a buyout order. But I am unable to accept there might not be circumstances where the other relevant factors all pointed so strongly in the opposite direction as to overcome that consideration. And my lady, one can see that there may be cases, for instance, there's going to be a bidding war. There may be cases where one would just say, no, there cannot be a sale at auction because it will be rigged or because there's been an artificial bidding war and so forth. What actually happened?
If you read the next paragraph, you'll see. We come back to it.
Of course, yes. Paragraph 35, I think I might say yes. My lord, my lady, paragraph 35, if you could read that to yourself as well, Mr. Tennick, ask you to draw that to your attention. So, just looking at the result of this case, you can see what actually happened, notwithstanding the judge's concerns that a bidding war was sought, that the objecting party might actually be seeking to engineer a bidding war. You can see the actual order the judge actually made at page 264. It starts at paragraph 92. And the judge then comes up with a halfway house between the two competing contentions at 95. For the following reasons, it seems to me that the fallback solution of a sale followed by buyout is the appropriate course in this case. And then he goes on to say why, despite his reservations about the bogus bidding war being engineered, he's prepared to order a sale in the first instance. See the reasons he gives in subparagraphs 1 to 4, and it continues. But he gives a series of reasons why that would be the course. So in other words, if there is reason to suppose there is going to be, that an auction is going to be in some way unfair, it's going to be rigged or whatever, then of course what the court does is, it doesn't say, let's go to the transfer. It says, let's deal with the problems about an auction by making directions as to how to deal with the problems that might arise if one partner tries to misbehave. And so, my lords, my lady, if I can just summarise what I say one gets from these cases, I've already made comments in passing. The question, my first proposition is, the question on the winding up is, what is the appropriate machinery for giving effect to the partners' rights to a pro-rata distribution of their shares? Second, normally, a sale by auction, or at least by private treaty, at which all partners can bid in the open market, is the appropriate machinery. This is because no partner is forced to sell at what may in fact be an undervaluation, if you go down the valuation route, thereby giving his co-partner an unwarranted advantage and an excess in the ultimate distribution over what that other partner is entitled to. There are special cases where this is not the appropriate machinery, but these, in broad terms, are limited to the following types of case. First, where a sale would cause undue injury to partners who hold a large majority. And it is not what the very much minor partner could seriously have envisaged as intended when he entered into the partnership. That, I say, is what you get from size. Another example, similar but not identical, is where a sale would cause undue damage to the partnership in return for no real benefit either to the person seeking the sale, and would produce damage to the remaining partners in relation to the remaining partnership assets, which were not put under the hammer. And that's Hammond. The third type of example is where, anyway, even though the majority have behaved badly, and one might therefore say that they should be subject to a sale, they could in any event have brought about the same result lawfully had they exercised their powers under the partnership deed, and that's Mullins. However, we say that where factors of that type do not exist, and the sale by auction or by private treaty would be fair and workable, there is no good reason to depart from the usual rule. We say that is for two related reasons. First, to do that would expose one partner to the risk that the other will obtain more in the winding up than he is entitled to, or was indeed envisaged at the time of the partnership. The second is this. The partner who wants to buy the property, that is to say the partner who says he wants to transfer to himself, can always bid for it himself. And I say that is absolutely fundamental. And if that happens, one of two things will happen about which he cannot complain. Either one, he will pay more than the putative valuation. You obviously in this case won't know, but he will pay more than what a valuation would come up with, in which case that is what the partnership should receive. There's no reason why the partnership shouldn't receive that. Alternatively, B, he will pay less than what the valuation would have come up with, but in that case, you say, he cannot complain about being forced to go to market and getting the property cheaper than what the valuation would come out at. Nor, in my submission, can the co-partner complain if a sale is what he required in any event. And in particular, I say, in connection with those general propositions, the fact that one partner owes the partnership a substantial debt is not a sufficient reason for departing from the usual rule, where the partnership assets are more than sufficient to pay off that partnership debt, or to soak up that partnership debt. And we say this, were it the case that a substantial indebtedness owed by one partner would justify departure, were that the case, the usual rule would become anything but the usual rule. Because it is likely, in a number, I don't know what type of percentage, but a large number of cases that there will be partnership debts owed by one partner which considerably exceed those owed by another or by others. And then you'd be opening the door to the partners who don't owe the debt saying, well, we want a forced transfer, please. It's much quicker, cheaper, all the rest. Valuation more reliable. In my submission, that cannot be right. And I go back to the point I made when I went to the Partnership Act. The debts of the partners are to be taken into account in the ultimate distribution, not in relation to how the machinery works of in trying to get the proceeds in, or not in deciding whether there should be a sale. And I say not only does it apply to a debt, normal debt, likewise that applies to a judgment debt. And in particular in this case, the judgment debt is carrying interest. It's carrying lots of lovely interest, 8% per annum, owed to the partnership. And in real life, that will be to the benefit of Mr. Bahia. That, again, is not a sufficient reason for departing from the usual rule. So that's what I say generally about the law. And I propose now just to go to deal briefly with my three grounds, because in a sense I've already anticipated most. The first ground I submit is, in one sense, the most unanswerable ground. And that's the point that the judgment debt was £3.6 million odd, whereas the total value of the assets against which have been transferred forcibly are 5.57 million, even on the Alexander Lawson value. Maybe a bit less if one takes into account the new value. It doesn't really matter. There's a big discrepancy. I say this: the total likely value of the partnership assets was something like 13.8 million, or something in that region. Second, the debt, the judgment debt that was owed as at the time, inclusive of interest, was 3.5 million. Therefore, on the judge's own logic, there was no need to order a transfer of more than 3.5 million by value, as it were, in order to satisfy that judgment debt, if this was a relevant way of proceeding at all. And therefore, if one goes back to page 66, paragraph 27, of the core button, I can just go to, I showed you this earlier, but I just show it to you again from now. Page 66. You'll see halfway down the page, 4 properties in question, as according to the Alexander Lawson valuation. There was no basis for saying all 4 of them should go to satisfy, so to speak, or to meet the problem raised. There was a problem by the 3.6 million debt. One alternative would have been to transfer properties 1 and 2, which convenient enough gets to about 3.6 million. Or the other way would be to transfer properties 2, 3 and 4, which gets to about the same figure. My lords.
The original application of Mr. Bahia was for 2 properties to be transferred in the first instance. Was that 1 and 2?
I can't remember. Yes. And we say that if only this ground were to succeed, then there's no reason for keeping item 1, or rather, there's no reason for not transferring back, or rather, item 1 should go to auction. Simply, because you've got items 2 to 4 satisfied if it is a relevant consideration of indebtedness. But item 1, there's absolutely no reason for it, and that is what, if we win on this ground alone, we would want item 1 back in any event, to be put to auction. My lords, my lady, we also say that the judge's justification for this, in his judgment, namely, or rather his way of dealing with this problem, namely, to give my client, so to speak, the first proceeds from the Schedule B properties, because the way the order is drafted, I can go back to the order. The way the order is drafted, there was some toing and fro, but what the eventual order was in relation to Schedule B, and this was the idea in his judgment, Paragraph 9 deals with how the Schedule B properties will be dealt with. Paragraph 9, there's a general power in the receiver to sell by private treaty or by public auction. They are to appoint estate agents. And then item 12, as the properties in Schedule B are sold, the receiver may make interim distributions to the claimant and the first defendant. On the other, interim distributions shall be paid with a view to ensuring equality between them, so that if at any point one party has received or is deemed under the provisions above to have received interim distributions ahead of such other party, the receiver shall seek to remedy this as soon as possible. And I think the judge explains this in his judgment. What he's seeking to do by this order is, because the respondent has received notionally at least £5.75 million by virtue of the transfers, he's already had an interim distribution which exceeds our debt of 3.6 million. And so he's saying, well, that can all be equalled out by us getting the first, what you might call, slice of the relevant proceeds. But in my submission, that doesn't meet the point. Our complaint is not about the speed of interim distributions on this. Our complaint is that it's completely wrong that 5.75 million was forcibly transferred away from us. And the problem is not solved by saying, well, you can get paid first in relation to the Schedule B properties. I should have to hand, but I can't remember exactly where the judge deals with this point in his judgment. I think it may be, it may not be in his judgment, it may be actually in what he said to the parties afterwards, which I did have a reference to, but he explains after his judgment in a note to the parties what his thinking is. I think one finds that at tab 17. Page 234. And I think this is an email by which he communicates through transfer listing with the parties, and you can see what he says in particular. I think it's when he says, in other words, halfway down the page.
Doesn't quite deal with the point of this.
Sorry, my lord?
It's not obvious to me, but it quite deals with the point about priority distributions.
No.
Well, that's I think, my lord, my lady, I think that's undoubtedly what he's intending. When he says the effects of the third paragraph up from the end, the effect of points A2 and B2 is to reduce the disparity between drawings caused by the value of the Schedule A properties being greater than the Bahia judgment bed.
But
So it's another email. Might be the previous one.
Okay, it may be, my learned friend says it's the proceed from the judgment. Not sure we have it in the bundle, but I think I'm right in saying, in general terms, that the idea behind this was that it's implicit in the way the order is drawn, that the first distributions, and this is how the parties I think have understood it, that the first distributions are be given from the sale of Schedule B properties to my clients to make good the disparity.
yeah. Well, it's envisaged at the bottom of page 76, but I'm searching in the judgment to find the judge's justification for ordering the sale of properties that are more than, that on anybody's valuations are worth more than the debt.
Well, there isn't one. It's fair to say that what happened, even I think it's fair to say even the respondent did actually draw attention. If we go to page 229,
Yeah.
before, I think this is when the judgment was still in draft, a significant issue that's arisen is to the treatment of the interim distribution of Schedule A properties. The Sidhus have pointed out that the effect of the distribution of Schedule A properties will be that any view this will wipe out the judgment debt by way of deemed distribution. They agree with that analysis. The effect of the transfer of the properties to the claimant will be that
1.9 million more. Yes.
more. But
No, it says, well, it wipes out some costs.
yes,
So what?
yes. Well, that's our position.
So there's a proposal at the bottom of 230 from the claimants that the Sidhus should receive the first 1.9 million from the sales. Well, that's the claimant's proposal. And
Well, look, there's an email from the judge at 233.
yes, I was just looking at
That
that.
was
It's
the
not
document
very-
I was trying to.
Yes.
It's not very easy to read, but that does seem to suggest that that's a response to that proposal.
Well, my lord, would it help if I read it? Because I've got the advantage of being able to expand it.
Ah,
Yes.
He says, I think the way this needs to be dealt with is as follows. The properties have an original assumed value, which may be revised upwards of 575,000. He means
Sorry,
five.
which page are you reading from?
I'm reading 233.
He means
Where?
5.57.
He does.
5.57.
2. Mr. Sidhu's estate has the following liabilities. 1. The judgment debt to the partnership in ASL, understood to be around 3.6 million as of the 1st November, if we take as correct numbers mentioned in the judgment. And 2. The Sidhu's judgment debt to Mr. Bahia of 50,000 odd on the same basis. 3. At the point of transferring the properties, there will be an interim distribution to the claimant and to Mr. Sidhu's estate as follows. 1. Mr. Sidhu's estate obtains the benefit of the deemed satisfaction of the judgment debt to the partnership in ASL mentioned at 2.1 and is also deemed to have received a dividend equal sufficient to discharge the judgment debt mentioned at 3.2, which it then transfers to Mr. Bahia to discharge that judgment debt. 2. Mr. Bahia is deemed to have received a distribution from the partnership of the value of the properties, i.e. again he means the 5.7 million, subject to upwards only revision, less the value at the point of transfer of the judgment debt, which it is deemed to have had direct from Mr. Sidhu's estate, so about 525,000 from the partnership. 4, and I think this is the point the court has asked about, this leads to a timing inequity in that Mr. Bahia has had a larger interim dividend than Mr. Sidhu's estate. The receiver should seek to rectify as soon as reasonably practical this, as cash becomes available for further interim dividends. Anything not dealt with by means of interim dividends will be delay within the receiver's final account.
He means dealt with.
He does. This is a slightly different solution to that in my draft judgment, but I think it is the fairest solution that can be devised given the complications of accounting as between the parties, and as between the parties and the partnership, I will revise the finalised judgment to reflect the above solution. And indeed, that did happen. So the Sidhus did acquire the 8 King Street property, so there was a distribution to them, and it is common ground that the parties are now completely equalised in the distributions.
So the Sidhu's got a property.
Yes, they did.
How did that happen?
They-
Because there's no provision for that.
They
bid
bid
at
for it.
bid for it at auction.
Yeah.
And is that what that email you've read is that reflected in what is now paragraph 12 of the order at page 57,
I believe so, yes.
which is subsequent to this exchange of correspondence?
Correct. So it took almost a month to draw up the order. There was a lot of to and fro.
Because although the order is dated 30th November, it's not sealed until the 19th of December.
That's right.
Yes.
Yeah. So it was it wasn't at auction. It was a private treaty sale of 8 King Street to the Sidhus, and that equalised the positions. There have been subsequent sales. There is, as I say, it's common ground that the partners are whole and equal at the moment on the basis of the Alexander Lawson valuations.
Right.
I'm grateful for my friend finding through the document I was trying to find. All that said, it doesn't answer the main point. it answers the point about speed of return, which is not our complaint. Our complaint is that there should not have been a forced transfer on any footing over £3.6 million, 3.5 million. That's that. And it's not made good by saying, well, don't worry, little heads, you'll get first dibs out of the Schedule B properties. It shouldn't have happened in the first place. The remedy was no remedy for the wrong. That's what we say on the third ground, which we say is difficult to see what serious answer there is to. And I'll turn to the first ground, namely, as I have said, the judge found our proposal to be workable and not unfair. Paragraph 59 of page 72. And we say that on the authorities, for the reasons I've gone through, given the value of the partnership assets and given this finding, there was no basis for departing from the usual rule. And the judgment debt was no basis at all for departing from the usual rule. And we say there is another vice in the order that's related to the fact there has been departure from the usual rule. And that is the provision for there to be a single joint valuer, a single valuer, whose decision is to be binding, save in the case of manifest error. And we refer in our skeleton to the Supreme Court's decision a couple of years ago, I think, in Sarah and Hussein Assets. It's at tab 13 of the bundle. And there's a discussion in this context of what is meant by manifest or mathematical error or manifest error. And it's paragraphs, and if I can just ask you to read yourselves, paragraphs 30 to 33. And I think this is in the context of service charge liabilities. Service charges. Page 273, paras 30 to 33.
Fairly dismissive of North Shore.
Yeah, well, no, wouldn't be for me to say.
Well, that was a conclusive evidence certificate.
Yeah.
Not quite the same, but yeah. Yes.
But essentially, it means the manifest error is one that's obvious or easily demonstrable without an extensive investigation, like paragraph 31. The trouble is, you then ask yourself, well, what does that mean? And you have to go to paragraph 32. It was said that manifest errors were oversights and blunders so obvious and obviously capable of affecting the determination as to admit of no difference of opinion. So, now, there may be a slight differences in nuance between these tests.
It slightly depends on to what extent the valuation is a speaking valuation or just a figure. We're told it is available in draft. How detailed is it?
It's 80 pages long, but the gravaмен's on a single page, and I thought to print out a single page and not the other 79. But I thought that was likely to be more acceptable. I don't really want to interrupt my friend's submissions, but there was no magic about the word manifest error. This is a case absolutely replete with argument at every single turn. And what the judge was trying to do was to narrow as much as possible the chance of having a row.
My question was, is it a speaking, what in other circumstances is called a speaking certificate? In other words, explains how the valuer has got to his figure, or does it just say
yes,
the answer is X?
So it goes into enormous detail about the properties, about their situation, about the market, about how they are zoned. It looks at comparables.
Then it might be easier to point to manifest error if he said, for example, that it's 20,000 square feet and it's obvious that
of course,
that's a mistake for
exactly.
30,000 square feet.
Exactly. So he doesn't just pluck a figure out of thin air and say it's X or Y. It's built up from the ground up. What you get to is a position where he gives his view on the right valuation, and equally says it's not an exact science. In my opinion, another valuer who arrives at a valuation at a level that's greater or less than mine by up to 5% has effectively arrived at the same valuation. 10% is a reasonable margin, 15% you'd want to have a look at it.
My point, I mean, I take my first point. My point is that my client is, in any event, this valuation will supersede and will be difficult on any footing to challenge, and that is the real point, because we say the matter should go to the market in any event. It's as simple as that. And it would be wrong, we say, to impose on either partner, when you have a 50-50 partnership, this sort of provision by which he is tied, whether or not there is eventually a speaking valuation.
So just translating that into my own words, your submission is, why incur the difficulty and expense of someone opining as to market value when you can find out the true market value by simply auctioning it?
You go directly to the source, so
Yeah.
to speak, the original source. You don't look at what someone else is guessing. You say, let's have a look at the source. And there's simply no injustice in that. That's my real point. Either it is going to be a higher value, higher price.
It's going to be lower.
Sorry?
Or it's going to be lower.
Lower.
You take your risk.
Yeah.
You go out there, you test the water, and you find out what somebody is willing to pay for it. And the bidding war point doesn't seem to be one that's emerging in this case.
No, there wasn't suggested there was going to be some artificial bidding. So we say that's the proper approach, for all the reasons we've set out. I've essentially gone to by saying no sufficient reason. The existence of a debt owed by one partner, even if it's a big debt, is not a reason for departing from the usual rule. It's as simple as that. It's a very simple submission of our first ground. The third ground is taking into account irrelevant factors, even if there was a power to do, or even if it was right to go down or think of going down the valuation route. I'm conscious of the time. Perhaps I can just ask you to pick up our skeleton, and we refer to these paragraphs. It's page 39 of the core bundle. I'm not going to read out what the answers. I'm just going to refer you to the judge's points, which are summarised in italics. I think there are 5 points he makes. The first point is, he said it was a sufficiently relevant. I think I took you to this paragraph. It's a sufficiently relevant consideration that an immediate transfer would allow for swift repayment of the debt. Special attention should be paid to his preference. We simply say the judges, that's not a sufficient reason for departing from the usual rule at all, for the reasons I've already given. Second, he says he held there was no certainty as when an auction would take place, or that the properties would sell in auction, but that is always the case, so what? Third point, holding that a transfer to Mr. Bahia would cost less than going to auction. We don't know. There's absolutely no evidence of that.
You do know.
Well, no. My inference is, well, the judge certainly didn't know at the time.
There was no evidence before the judge, is your point.
Yes. There was evidence, I should say, of the cost of going to auction. That is true. There was no evidence of what the valuation, the ultimate cost of the valuation process would be. Take into account not only the valuer's costs, but the solicitor's costs in arguing about it. Fourth point on the page 41, holding, the judge held, well, it's relevant that the Sidhu, my clients, would benefit from interest ceasing to run at 8%. Well, that's a matter for my client. It's not a matter for the court to say, look, I've got a good idea for you. If my client wants to take the risk, he's entitled to take that risk.
Well, also, when you start divvying up the shares, the more that the interest starts to run, then the bigger the debt that then comes out of your client's share at the end of the day.
Yes.
So, what difference does it make? I mean, it just means that they're worse off at the end of the day, but that's the risk they're willing to take.
They're willing to take that. I'm prepared to run the risk of this accumulating interest because I think if it goes to auction, it's going to get a better price.
Yeah.
That's my risk. But it's not a risk for Mr. Bahia at all. He's entirely protected by that. So that's not a relevant consideration. And then the fifth point on page 51, holding it was relevant to have regard to the fact that Mr. Bahia's sole surviving partner was entitled to discern the means of disposal of properties. No, just say that's wrong. That's not what the authorities say. And so, my lords, my lady, those are my submissions. We say the appeal should be allowed on ground 1, ground 2, and failing that, ground 3. And the order should be as we seek.
But to be clear, you took us to what you put into this later skeleton, and that's helpful. But in answer to my Lord Justice Nugee, you explained that your client's primary objective is, of course, to achieve a sale. Yeah. And so you don't have any objection to a short-circuiting order which simply directs the respondent to sale.
Exactly. And we have no objection to that.
Yes, all right. And that, of course, if you are successful on your appeal. Yeah. Thank you.
Thank
you. Mr. Temming.
My lords, my lady, what my learned friend has just done is rerun the application that we made and that we had prefaced before the trial in front of Mrs. Justice Joanna Smith some 2 years ago. And that's not what this court ought to be doing. The starting point is what Lord Justice Lewison said when moving this application into court, where he said, I can see no error in the judge's summary of the legal principles at paragraph 16 to 25, and none is alleged. What that means is that this is an appeal against an evaluative judgment, and as this court knows well, appeals against an evaluative judgment are of a wholly different nature to other appeals. The authority for that proposition is Sprint Room. Do I need to take the court to that? I'm sure you're sickeningly familiar with it.
We get that every week, so no.
Well, I'm glad I don't have to do that. But my lords, my lady, it is important because this isn't supposed to be a court where you just get a second bite at a cherry when you have lost an application about how properties are to be divided up. And if we start with the principles, which are the principles of law which are not challenged, the most convenient place to do that is, in fact, the judgment of Nicholas Thompsell at paragraph 16 to 25. And it's important because my learned friend makes an error in his formulation of the legal principles. The starting point, the judgment is at page 63 of the relevant part of the judgment, is page 63 of the call bundle. Starting point is section 39 of the Partnership Act. And the point about section 39 of the Partnership Act is it does not require the assets of a partnership to be sold in order to dissolve it.
When it says to have the surplus assets applied in payment of what may be due, does that mean then that a transfer in specie is an application of the surplus assets in payment?
Yes, it does, and indeed that was part of the application we made. In one sense, the 3.6 million judgment debt is a bit of a red herring, because we made an application for transfer of the properties in specie at the first trial, at the trial before Mrs. Justice Joanna Smith. And I'll take your lordship to that, and indeed to our application about how it should be, how it was going to be dealt with when we look at the orders made after that judgment. The 3.6 million judgment debt was a feather in our cap, or at least so we thought until we turned up here this morning.
Well, the historical explanation is helpful, and it may indeed be helpful to learn more about the history. But I'm struck by your phrase that the judgment debt is a red herring. Would you accept that the judge was in error if he thought that the judgment debt was a sufficient reason for departing from the normal rule?
No, because it's definitely part of the evaluative decision-making process he came to.
In which case, I'm a little puzzled by your description of it as a red herring.
Well, maybe
Perhaps that isn't what you meant to say.
Maybe I put it. Maybe my understanding of red herring and your lordship's is are different, and in that case, it's my fault
The
for
red
using.
herring is a distraction and an irrelevant.
Yes, it's an issue which supports and supported my case for why the judge was right to deal with the properties in the way he did. And my lord, can I don't want to take it out of order, but I would like to show your lordships how this whole application developed and how the order came about, because my learned friend was right to say that the positions changed at the hearing, and I'll show you that effectively we were responsive to the way that the respondent came up with his new device, which was to give us a credit. The respondent accepts, I think, and certainly accepted before Mr. Thompsell, that it was unfair to put all of the properties onto the open market and say, you both have a go at it, in circumstances where one of the partners had stolen 3.6 million from the partnership. Because what that did was give that partner 3.6 million pounds in the kitty in his hands in order to purchase partnership properties which we were deprived of.
Well, and at that point was accepted and was addressed by the offer of the credit.
In the hearing, correct, yes. My lord, I was just dealing with the undisputed legal principles. I'm doing it, I hope, in a short-circuit way by reference to the original judgment. Lord Justice Nugee just pointed out the passage of Lord Brightman in Latchin and Martin. The section doesn't require surplus assets after creditors have been paid to be sold. It requires merely that they be applied in payment of what may be due to the partners respectively. So we say that does allow transfer in specie. Lindley and Banks, of course, the well-known textbook, is cited at paragraph 19. That's also, those principles are not in dispute. In the event of a general dissolution, each partner is normally entitled to insist that all the partnership property is sold. And this is where my learned friend puts the test the wrong way round. Each partner is normally entitled to insist that all the partnership property is sold, even if the firm's debts and liabilities could be discharged without such a sale. However, as was found in the case of Benge and Sayers, this normal position is usually adopted in order that justice may be done to all parties when no other course has been or can be agreed on. But, as was said in that case, that's Sayers, it's not an arbitrary rule inflexibly applied in all cases, whether it's necessary or not. And although if one partner or his representatives insist on a sale, the court may not be able to refuse to enforce that right, still the court is always inclined to accede to any other mode of settlement which may be fair and just between the parties. So my learned friend, pointing to the judge's judgment, saying, look, these two proposals might be fair and aren't necessarily unjust, is absolutely nothing to the point. Because so long as a mechanism is fair and just between the parties, that is acceptable.
What does it mean to say if one partner insists on a sale, the court may not be able to refuse to enforce it?
That's, I think, in a circumstance where the partnership agreement provides that on dissolution or maybe on death, the assets are to be sold. And that's why my learned friend took you to cases where there was construction of different provisions of partnership agreements and what they meant and what that required. We don't have that in this partnership at will.
I'm not sure that's right. With respect, having looked at the quotation in its original context, I thought it was set against the context where there was no agreement in the partnership the other way. In other words, it was where the partnership's silent about what should happen, and what Lord Lindley was saying is that if the partners agree between themselves that there should be a distribution in a particular way other than sale, then the court will go with that. In the absence of that, it may not be able to stop one of the parties enforcing a right of sale unless there is some alternative which is fairer.
Well, we can look at it in the original. I think this is in Benge.
Yeah.
So it's in the authorities bundle at page 184, where the deputy judge is looking at the sire's jurisdiction.
I think it was Sires itself I was thinking of.
Well, I don't want to take a technical point, but this is what the judge found there, and it's not suggested there was any error in the judge's summary of the legal principles. That's what Lord Justice Lewison found. But in any event, looking at the judgment at paragraph 47, that was what I was just reading.
That's a quotation from Lord Lindley, so it's a question of what Lord Lindley meant by it, isn't it?
Yes, I can take your ladyship back to that in a moment, but before I do, can we carry on? It's 47 to 49, but then importantly 50. But 49 says the court will have regard to a number of factors as stated in Sires itself by Lord Cairns: the nature of the business, the relative interest of the parties, what it is that sought to be done with the partnership business. That is, in this case, Dean Farm. Often it will be a partner of a very significant majority. In Sires, it happened to be 7/8 who wants to continue to carry on business and to use the assets of the partners, and in a way that might be regarded as a paradigm example, but it's not an exhaustive description of the circumstances in which this Sires power might be exercised. 50. It's a mistake, as was observed in the Hugh Stevenson case, to suppose that winding up under the Partnership Act must necessarily involve a sale. It's a matter of the discretion of the court. But the cases show that a sale is the normal starting point, and it's been referred to as a presumption as to what is just in relation to winding up. Lord Justice Hoffman, as he then was, observed in Hammond and Brearley that whilst it's true that a sale by auction is the normal way of realising the assets for the payment of debts and distribution to partners, there are exceptional cases in which the court can take a different course, and the obvious alternative to sale is for one partner to buy up another. So that's where this idea of exceptionalism comes from. It's from Lord Justice Hoffman in Hammond. But there are circumstances which were exceptional in this case. The fact that there was only one remaining partner, that the partnership was dissolved, that there were findings of 3.6 million, including interest, having been stolen from the partnership by one of the partners. And in circumstances where both the estate of the deceased partner and the remaining live partner, I mean, I'm not sure whether we call him the remaining live partner in a partnership that's been dissolved, but in any event, Mr. Bahia wanted to continue with the property business. It was obviously completely unfair to allow one partner to sit on £3.6 million worth of the partnership assets and then say, oh well, we can just have an open bid in the market. And that was one of the things we prayed in aid. But can I just take the court back?
Yeah, and you were justified in taking that position, but I still don't understand where that gets you to in circumstances where the credit mechanism deals with it.
Because that's only one of the issues.
Because you're not arguing costs here. You're not saying, we're not concerned here with the question of, well, costs were wasted because that wasn't made earlier. We look at the positions of the parties as they were expressed to the judge at the hearing, don't we?
Yes. But can I take the court through the background to how the application was made and what we were actually seeking?
Sure.
Then look at what the judge actually ordered. Because it is fair to say that the judge ordered more than we had asked for, in the sense that we asked for the first two properties to be transferred to us immediately in satisfaction of the judgment debts. We asked for the next two properties in the list to be transferred to us, I think we said henceforth or thereafter, I forget which, even at the dissolution, but we did still ask for those properties, and the way we asked for it, well, I don't know why I'm doing it without taking your lordships and your ladyship to to what we did ask for. So, first, the order of Mrs. Justice Joanna Smith, the relevant order is in the supplemental bundle at 113. This is when the appellant was on his second silk, now on his third. You can see that there was quite a lot of business in at this hearing. And we can get down to the recusal application isn't important for these purposes. Mrs. Justice Joanna Smith said she would recuse herself from the contempt proceedings. There are directions for the contempt proceedings that the trial of the perjury point is coming on next year. And then we get to the property transfer application at 115. This is a different application. This was an application by the Sidhus, which was dismissed as being totally without merit. Then we had amendments to the receiver's power, and then questions about valuations. And you can see here at paragraph 7 that there was a mechanism to ask questions about the valuation of Alexander Lawson. That written question should be sent to the valuer. There was going to be a stay of the proceedings for mediation, which was unsuccessful. And then at the bottom of page 116, we get to the point about the disposal hearing. That was the hearing which came on eventually before Mr. Thompsell. And the questions were to determine whether the properties of the partnership should be sold or whether they should be dealt with or disposed of in a different manner. On either alternative, the court will make such directions as may be appropriate. And there was a point about whether Mr. Pablo could resign as receiver. And then there were directions about the disposal hearing in paragraph 12, heard before the judge if she was available, and then us to set out what order we were seeking, and so on and so forth. So we did set out what we were seeking, and that you can see that in the core bundle at page, tab 11, page 167. And I think probably the order that we sought is the best place to look at what the application was about. That's core bundle at page 1.
Sorry, tab 11, page 167, which bundle?
The core bundle, my lady.
Ah, sorry,
167 is the application notice. I think it's the order that is probably the most convenient way of looking at what we were asking for. That starts at page 170.
Right.
And at 171, what we were asking for was that the properties in Schedule A be transferred to the claimant by the receiver for one half of the Alexander Lawson valuation, and that we wouldn't have to pay for those because it was going to be an in specie transfer of those properties. And the reason we didn't have to pay for them was because of the 3.6 million judgment debt. The properties in Schedule B, which was the remainder of the partnership properties, would be sold at the receiver's discretion, whether by private treaty or by auction. And then on completion, in paragraph 4, you can see that we asked for completion for 2A, the Broadway, the Ealing property, and the King Street Southall property straight away. And then subparagraph C on page 172, thereafter, the remaining Schedule A properties will be transferred at consideration equal to one half of the values stated in Schedule A, where the receiver holds sufficient funds to make an interim distribution. Now, in the skeleton that we put in for that application, there was a long passage about how difficult it was to enforce in circumstances where the estate had been denuded by Mr. Sidhu of the assets. That's long, boring, and we don't need to go into it. But there is a hopefully less boring and shorter section from paragraph 30, which deals with what we were asking for. And we said the basic proposal is that the properties are transferred to him, that's to Mr. Bahia, in advance of the finalisation of the dissolution accounts by providing appropriate accounting adjustments rather than making cash payments. In the alternative, he'd nonetheless seek an order that the properties are transferred to him in the same manner upon final resolution of the accounts. So again, the 3.6 million was I'm not going to call it a red herring now, having been gently rapped on the knuckles about how that might be putting it too high. But it was certainly a distraction. It wasn't necessary. It wasn't a necessary part of what we're actually seeking.
Well,
the gravamen of
can
what
I
we're
ask you
seeking
about that? Because if you look at paragraph 32 of the skeleton, it says the draft order attached to the application envisages the initial transfer of 2 properties by way of an instant distribution in order to offset the sums owed by the Sidhu estate pursuant to the order of 12th April 22, circa 3.6 million. So
yes,
why is it not accurate to say that your client's case before the judge was, I've got a judgment debt of 3.6 million, you should order transfer in specie in order to address that judgment debt?
that was part of it, but that wasn't the gravamen of this. Was transfer these assets in specie. Don't mind whether it's right now or whether it's later, but if you're going to do it right now, then we'd like those 2 properties and we can extinguish the judgment debt, which is continuing to accrue interest at 8% in the meantime. But it doesn't matter. I mean, I don't want to get into a row about what we were seeking or not. It is right that we were seeking the transfer. As I say, the gravamen of what we were seeking was the transfer in specie of those 4 properties.
And
Timing was less.
What I'm trying to get my head around at the moment, I entirely understand the first 2. Why were you saying that you wanted or were entitled to a transfer in specie of the other 2?
Because we wanted them. Because
you wanted them.
Yes, because the Partnership Act doesn't require a sale of the assets, and so we sought on this application a transfer of those 2 properties. Mr. Bahia wants to carry on the business that he has been running since the early 70s. That was the relief we sought at the very first trial.
Is it your submission that you don't need to show any sort of exceptional circumstances, and that the court has a free hand if one of the partners actually wants some of the partnership assets to give him those assets?
Well, the starting point is the Act. I think I have to accept that I'm slightly constrained by what was said in Hammond and Brearley, which says that that does require exceptional circumstances, but there were exceptional circumstances in the reasons that we talked about, in the fact that one partner was surviving and wanted to carry on the business, in the fact that there was the judgment debt. I realise, of course, that would be extinguished by the transfer of the first 2 properties. And indeed, in respect to the 3rd and 4th properties, we said that can happen at the end of the process. And one asks rhetorically, why do you have to sell everything in the partnership dissolution at the end of the process when somebody, and it's usually in this case it will be the court, has to determine the final divvy up? Why does it have to be in cash? Why can't it be a transfer of the properties where one party wants to continue? It's always different in a case where there's a surviving partnership or a surviving partner, and one partner says, I really don't want that to happen. I don't want you to have the goodwill that we both brought up together. But that situation doesn't pertain in the case where you've got a dead partner.
Well, in a sense, the fact that there's a dead partner is, while an important part of the history of this case, doesn't seem at the moment to me to be a particular point of legal principle. But what you have made is a more fundamental submission, which is what's wrong with a transfer in specie. And I see the force of that point. But what will you say to this question? Assume you're right about that, at least at one level. Surely what the dispute here is about is not actually at bottom really about whether your client gets a transfer in specie or gets cash. The dispute is about valuation. And the dispute is about what's the best mechanism for getting a valuation. Because actually there's no dispute that your client can acquire the properties if that's what he wants to do. The question is, at what price? And the real dispute in this case, it seems to me at the moment, is whether one should value by means of an expert or value by means of an auction?
Yes, you can get even more reductive than that. This dispute is about, this appeal is whether the only way to establish the right value of a property is to sell it at auction. And Malone and Friend says on his feet today, or by private treaty. And the judge said, in the exercise of his evaluative, or in his evaluative judgment, no, it isn't the only way. And he said, if auction were the only way to achieve the best value for any property, everyone would always sell their property by auction. And you can take judicial notice of the fact that that's plainly not, doesn't happen.
I presume you would accept that these are investment properties.
Yes.
Yep.
Was there any evidence as to a normal method of selling investment properties such as these? Because I would have thought auction would be the usual method. But
No, there wasn't. But there was evidence from the receiver who said, who was given powers, I think by consent actually, and given powers to sell the remaining properties by whatever means he thought best for them.
yes.
So there was a nursing home for one, there was auction for another, nursing home by private treaty for one, auction for another, private treaty for 8 King Street, that's one of the Schedule B properties, that's the one which went to the Sidhus. So we relied on his experience and his knowledge about what was the best way of doing it. There was another issue before the judge about whether these properties should go into an auction at with a reserve on.
Reserve, yes.
And if so, what that reserve should be. Should it be at the Alexander Lawson valuation? What was going to happen if it didn't meet the reserve? I'm going to get onto the figures after lunch, but the figures are absolutely astonishing because the Alexander Lawson valuation is within 1% of what the properties have in fact sold for. And as a whole of the 4 properties, the single joint experts draft report is also within 1% of the Alexander Lawson figures. So the myth that auction is the only means of determining a fair value of these properties is just that. And there was evidence before the court that on the Alexander Lawson valuations, and I say on those valuations because the cost are a percentage of the sale price, that was going to cost £74,000 or thereabouts for those properties. And we do now know, though the judge did not at the time, know what the cost of the single joint expert valuation is, and it's a fraction of that. It's £10,000. So when we look
That's including the legal costs.
Well, no, it isn't. That's the single joint expert's costs. But what I ask rhetorically, what legal costs in circumstances where the parties don't have a mechanism for engaging in massive to and fro about what the valuations are? Because whether one looks at manifest error as a term of art or...
No, it's before the manifest error. I mean, surely both sides have the right to make submissions to the valuer about what the valuation should be.
Well, as they did with the Alexander Lawson valuation.
Yes.
And both sides raised questions, and it wasn't until the hearing, or just, I think, a day or two before it, that those Alexander Lawson valuations were ever in issue. That's why, when we went to that hearing, we said we'd like the transfer at the Alexander Lawson valuations. We thought they were undisputed. It was the day before that suddenly he said, oh, well, you've got all these problems with them. I can show your lordships and your lady, my lady, from my skeleton argument, that at my skeleton argument before that hearing, we thought there was no dispute about the valuation at all.
Undisputed valuation.
Yes.
Very good. Is that a convenient moment to break?
Yes, my lord.
Excellent. And we'll resume at 2 o'clock.